I just want to make it real clear that there is to be no inappropriate comments or disruptive comments to be made inside of this courtroom. If anybody is found to make those, they will be immediately escorted out and barred for the balance of this. All right, I just want to make that real clear. And just in case you're wondering, there are microphones all around. And so if I get a report of that, there's going to be some serious issues and serious problems.
I just want to make it real clear that there is to be no inappropriate comments or disruptive comments to be made inside of this courtroom. That is the official record. That is the voice of a judge drawing a bright legal line in the sand, warning everyone in the gallery that the microphones are live, the decorum is mandatory, and violations will be met with immediate ejection. It sounds like standard courtroom housekeeping. But when you read that admonition against the motion that triggered it, the entire statement transforms from a procedural warning into something else entirely, a judicial tripwire placed directly in the path of the state's own prosecutors. Before we go deeper into what the documents actually show, make sure you're subscribed to Courtroom Verdict Vault, because we don't just cover the story, we follow the evidence. Think of a glass courtroom. You can see everything. The judge, the jury, the defendant, the attorneys for both sides. The architecture of justice is transparent by design. Now imagine a single crack racing silently across that glass, originating from the prosecution's table. A fracture so fine you can't see it with the naked eye, but one that has now compromised the entire structural integrity of the proceedings. That crack is 3 words picked up on a hot mic. Shut her up. The defense attorney, Kevin Reddington, refused the judge's offer to approach the bench for a quiet sidebar.
Okay, so again, that was from earlier today. And from our team that's there in the courtroom, we understand that what Reddington is referencing is his client's emotional response to the medical examiner who testified yesterday about the autopsy of her baby, Callan Clancy. So let's go back to that moment where she was visibly sobbing.
You could use the tool pressing the top button there just to highlight the area you're talking about, the abrasions on the neck.
Right here on his right side of his neck.
He wanted sunlight. He wanted the record to reflect, in open court, that when the medical examiner was displaying autopsy photographs of the defendant's deceased child, and the mother began audibly sobbing.
This is not like Handmaid's Tale where you're going to tape them up.
Listen, I'm not doing that at all. I just want to find out what the issue is. There's a lot of privileged issues, and then you can tell me that, and then if it was a witness.
Yes, we get it right.
I get sidetracked by that.
Someone on the state's side allegedly whispered a command to silence her grief.
So there's been a clip of this that's actually making its way around social media, and that may have been what Kevin Reddington was privy to, and he brought it up today with the judge. Let's talk about the impact that this could have on the trial. Here to discuss this case, we have board-certified forensic pathologist Dr. Priya Banerjee and trial attorney Alexis Rosenberg. Alexis, you saw the look on the prosecution's face when Kevin Reddington was making this claim that they said to shut her up. When it came to his client, they seemed incredulous that he was making that claim. He also made a reference to the Handmaid's Tale, that you can't just keep her quiet. Talk about your just initial reaction to these accusations that is very hard to make out, and it may be that we don't even know if it's prosecution that's speaking in that clip.
Well, if it was the prosecution, it was wholly inappropriate for them to make that comment. I think the defense bringing it up, it was appropriate, and the Handmaid's Tale did give us a little drama, but he also wanted it to be open.
He then drew a comparison not to a legal standard, but to a dystopia, stating flatly, "This is not like Handmaid's Tale. We're not going to tape them up." The prosecution's table sat incredulous, faces frozen in a mask of denial.
You could use the tool pressing the top button there just to highlight the area you're talking about, the abrasions on the neck.
Right here on his right side of his neck, and then in the middle of the neck and on the left side of the neck. And this is another photograph showing a bit more closely, again, the abrasions of the neck. There's one on the...
But the accusation had already landed on the docket. The crack was public. This is where the anatomy of a trial splits. On one track, you have the overt prosecution, the presentation of forensic pathology intended to prove cause of death. The medical examiner clicks through sanitized, demonstrative photographs of abrasions on a neck, using a laser pointer to highlight the right side, the middle, the left side. The testimony is clinical, measured, deliberately drained of shock value so the jury can focus on the science.
And Dr. Banerjee, as a forensic pathologist who testifies in situations exactly like this, the reaction to it can often be emotional.
Oh, absolutely. I think there's always a warning before I testify or any autopsy photos are shown. First of all, from your experience, we whittle down the autopsy photos that are demonstrative but not gruesome, just to try to contain the shock value. It's not meant to hurt, the case. It's meant to demonstrate what I saw or my colleagues saw at autopsy and how it helped determine my point of view regarding any case I'm testifying in. But all of this is tragic and very, very emotional. So we always caution anybody in the courtroom, but you have to think about it, it's especially with children. I mean, it is just so heartbreaking. And so, I would say her reaction's proportionate, but definitely it can be distracting as well when you're trying to give sort of.
On the parallel track, hidden from the evidentiary record but bleeding into the atmosphere of the room, is the subtext of human agony. The defendant is sitting at the table, not as a legal construct, but as a biological mother whose visceral reaction to seeing her child's body displayed on a screen is to weep uncontrollably. The forensic pathologist later noted that such a reaction is proportionate, that the tragedy of child autopsies is always heartbreaking, but also that raw emotion can be a distraction from a measured medical opinion. There you have the unbearable duality of the courtroom. A mother's involuntary cry of pain is legally permissible, constitutionally protected, and yet, from a strategic vantage point, it is noise to be managed.
Yeah, and a follow-up, Alexis, it sounded like from the judge's admonition, and he may have talked to these attorneys outside the presence of anyone, but it sounded like he wonders if it could be anyone inside of the courtroom. That's why he gave that after the jury was out, but while everyone is still in the gallery. What do you think?
I definitely think that maybe we don't have proof. Like you said, and what you've played, it's kind of unclear where it's coming from. Now, it may be that the defense was able to hear it better or see the angle that it was coming from. I don't know, but I would guess as well, Julia, that there was a conversation with counsel where he did maybe ask the prosecution, did you make that comment that was outside the jury in the courtroom? And they denied it, I'm going to assume, and then it was that instruction
That is the moral fulcrum upon which this entire case now balances. The state wants to paint a portrait of a cold-blooded killer, a woman who acted with intent and without emotion to commit an unthinkable act. Every tear that falls from the defendant's face washes away a layer of that prosecutorial paint. So if the state can't remove the defendant from the room, because she has an absolute constitutional right to confront the evidence against her, the temptation to neutralize her emotional display becomes a tactical imperative. The hot mic didn't capture a legal argument, it captured an impulse. Shut her up. It is the kind of raw, unguarded fragment that reveals the friction between the state's official duty to seek justice and its operational desire to win. The judge's subsequent blanket warning to the entire gallery, issued after a likely private sidebar where the prosecution presumably denied making the comment, is the legal equivalent of mopping up a spill that has already seeped into the groundwater.
At that time, that was yesterday, that was during the one medical examiner who's been on the stand so far, so we know the judge doesn't want distractions, and the defense will have to make that decision with the client, Alexis, as to whether or not she's going to sit through the next two autopsies, which have not been presented to this jury yet.
Well, she has the right, as we know, to sit through and hear the testimony. She has a constitutional right to be able to do that. The question is whether she wants to sit there or not. As a defense attorney, you want her there. And in reality, you want her showing, as a defense attorney, emotion and to be affected by this, especially with this type of defense. But as the prosecutor, you don't want that because you're trying to make her out to be this cold-blooded killer who has no emotion and went and intentionally murdered her children. So there is a balance in that. But
the jury is out of the room. The jury is protected from this contamination. But the integrity of the trial, that remains an open wound. You have to ask yourself the ticking, clock question that turns this from a courtroom procedural into a constitutional thriller. If the state is willing to suppress the involuntary grief of a mother during an autopsy presentation, what other evidence are they willing to shape, hide, or silence before the closing arguments are gaveled shut? We are left staring at a void where hard evidence should be. The social media audio is muddy. We cannot definitively identify the voice. We do not know if the whisper came from the prosecution table, a spectator, or an intern. But the weight of the accusation does not require a forensic audio match to do its damage. It only requires the context in which it was made. The defense established on the record that they believe the command to silence a grieving mother originated from the state's representatives. The judge felt compelled to issue a global gag order because the allegation alone was enough to endanger the fairness of the process. The prosecution now operates under a cloud, not of guilt, but of suspicion. Their denials are noted. Their incredulous expressions are noted. But the glass remains cracked. The trial is proceeding toward 2 more autopsy presentations, and the defendant will almost certainly be seated there, instructed by her counsel to contain herself, to try not to cry while the state displays images that no parent should ever have to see. The instruction to the mother is now the same as the alleged hot mic command. Just softened by legality, control your grief, suppress your humanity, so we can maintain the fiction that this process is sterile,